Welcome to this APC Q&A practice session where we'll take a look at some of the potential interview questions and model answers. Now, the Q&A that we'll discuss is normally classed as being the pass or fail type topics, where any failure to answer these questions correctly will normally result in a fail or a referral to anybody sitting their APC. Now, this is nothing to feel panicked or worried about, so please don't feel daunted by this or by the RICS interview in general, and I'll explain in a little more detail by what I mean in terms of pass or fail questions. All of the Q&A discussed is applicable to anybody sitting their APC, no matter which pathway you're on, and I really hope you find this video useful. I'll never claim to be an expert in this area, and I'm only speaking from my own experience of the APC and my experience having helped a number of colleagues successfully pass their APC over the last 5 years. Before we get into the main Q&A practice session, what do I mean when I say pass or fail type questions? Well, to address this, let's first of all take a look at the structure of the RICS final assessment interview. You can see that the interview starts with a brief introduction and then leads into your case study presentation. Following your presentation, there are 5 minutes of Q&A based around your case study, followed by 25 minutes of questioning on the core competencies. This then goes into the 10 minutes of Q&A by the chairperson, which is highlighted in green, and this really focuses on the mandatory competencies, RICS ethics and rules of conduct. And within this section, this is what we'll be focusing on today. And normally, any failure to answer these kind of questions correctly will result in a fail or a referral. So this is what I mean when I say that these are the must-know questions and answers. And as I say, this is nothing to feel worried or daunted by. These questions essentially are the rules of the club that you're trying to join. The RICS has a royal charter in place, and to keep that royal charter, the RICS and their members must adhere to a set of bylaws. The assessors need to ensure that you, as a chartered member, know exactly what is expected of you, so please don't feel daunted by this. And I think fortunately, with a bit of studying and hard work, it's really not impossible to get to grips with these, and a lot of the principles set out fall into a common sense approach. Some elements are very specific and will require some revision, and to assist with this, I've included a PDF copy of the Q&A model answers and some really good tips on interview technique, the best terminology to use when answering level 1, 2 and 3 questions, which you can base your revision around, and that's available to download in the link in the description below. For anybody out there feeling really daunted or just feeling like the APC is an impossible task, this really is not the case, and I did do a separate video on this, which I'd also recommend watching, where I tried to dispel a lot of the common misconceptions about the APC. So without further ado, let's take a look at some of the Q&A centred around the RICS ethics and rules of conduct, which fall into that pass or fail category. So the first question we'll take a look at is, can you tell me what the 5 global professional and ethical standards are that are set by the RICS? Now, this is something that you will definitely need to know in your RICS final assessment interview. The answers obviously are 5-fold, so to always act with integrity, to always provide a high standard of service, to act in a way that promotes trust in the profession, and to treat others with respect, and always take responsibility. You may then get a follow-on question to this, saying, can you tell me which 2 or 3 global professional standards resonate with you the most? And the assessors are just checking your understanding of the global professional and ethical standards. So just to go into a bit more depth on these, so always acting with integrity is always making sure that you're honest, open and transparent excuse me, in your dealings, and that you always look to avoid any conflicts of interest. To always provide a high standard of service is providing the best possible advice, support or performance to whom you have a professional responsibility. Acting in a way that promotes trust in the profession is always acting professionally and positively in both private and professional settings. Treating others with respect is always having courtesy, being polite, and being aware of any cultural sensitivities. And taking responsibility is just always being accountable. The next question we'll take a look at is, what are the steps you would need to take in order to set up a practice that is regulated by the RICS? Now, essentially, the assessors are aware that being a chartered member, you could walk out of the interview and tomorrow look to go and set up a professional practice that is regulated by the RICS and start displaying the RICS logo on your website or on your shop window. So they're just merely looking to try and test your knowledge of the things you would need to do as a RICS registered practice. So the first item you would need to carry out is to inform the RICS. You'd also need to appoint a contact officer. You'd have to register with the RICS for regulation. Make sure that you've got professional indemnity insurance cover in place. Set up a separate client business banking account for handling client money. You'd also need to have a complaints handling procedure and set up any CPD and training requirements for your staff members. The next question we'll take a look at is, would you accept a gift or offer of hospitality from somebody in a working capacity? So I think generally a good answer to this is that gifts, hospitality and promotional activity is generally acceptable and considered part of doing business. However, it is very closely linked to the Bribery Act 2010. Try and make sure that in your answer that you always act reasonably and proportionately, and also you could say that the Bribery Act does define acceptable gifts and hospitality, which you could sense check against. You'd also have to say that as long as the hospitality being offered was modest, occasional, if it's something like sort of meals or cultural events, but it must not be at all lavish or frequent. It's got to be conducted in the correct manner and in accordance with the Bribery Act and that list of hospitality or gifts that's defined as being acceptable in accordance with the Bribery Act. To go into this one a little bit further, because it is quite a sensitive subject here, you could also touch on that you could accept the gift potentially if it was of nominal value, if it was offered openly and not discreetly. It must not be regular. It must not be monetary or to influence any decisions that are ongoing. As your actions, you'd also need to make sure that you were acting fully, openly and transparently. You'd have to keep a record of any gifts or hospitality that you've received. And there must be real consideration. So for example, if you're undertaking a tender with a contractor and they offer to give you a gift or take you out for some hospitality, then the timing of that is just way off, and you should really tread carefully. And I'd always advise on rejecting that kind of hospitality. So obviously always give consideration to the value, the timing, making sure that it's proportionate. So moving on to question 5. So what steps must you take for the handling of clients' money? First of all, you must always make sure that clients must have access to the funds that have been sent. Clients' money must be kept separate and clearly identifiable. You must include client in the account name. Interest on the account must be agreed with the client. You should also maintain a client ledger or running balance of any transactions. You should always agree the terms and advise clients on the bank account details. And the account must never be overdrawn. So question 5 is, what are the RICS 5 principles of better regulation? So just to explain a little bit more about these, because I think these are often quite not tricky to get to grips with, but I often see candidates have a lack of awareness about these principles of better regulation. So just to explain a little bit more about these, the RICS has a Royal Charter allowing them to be self-regulated. They are self-governed by the bylaws and the principles of better regulation set out. So these are all just about how the RICS is a self-regulating body. So proportionality is effectively meaning that the RICS should only intervene when necessary, and any remedies that they impose should be proportionate. So for example, if one of their members were to pay their fees, their subscription fees late, that could be dealt with by a verbal warning, whereas continued failure to pay and lack of cooperation with the RICS may result in expulsion. So it's just all about dealing with their members proportionately. Accountability. So regulators must be able to justify their actions under public scrutiny and to promote complete fairness. So they should be able to always clearly explain why certain decisions have been taken. Consistency. So there must be a complete, fair and level playing field, treating everybody the same, no matter what background they're from. The principle of targeting is focusing on the problem and minimising any side effects from a scattergun approach. So any measures that the RICS does undertake should always be unambiguous and very, very targeted, as opposed to a scattergun approach. And finally, transparency. So keeping regulations simple and user-friendly and always effectively communicating. And also trying to avoid a heavy-handed approach where possible. So question 7, why does the RICS have rules of conduct? Well, these are to provide a framework that we can all work to, so the client knows he's getting a set level of service. As well as being an important tool for the institution, the rules of conduct are a useful professional guide for individual institution members. How many rules of conduct for members are there? So this is 9-fold, and again, you will more than likely need to know each of these within the RICS final assessment interview, so I think it's really worth just spending 15 minutes to half an hour going through these in some detail, just to make sure you've got a good understanding of each of these. Just to touch on these very briefly, so interpretation is the definitions that are set by the RICS. So MRICS definition refers to a member, whereas FRICS refers to a fellow. So those interpretations and definitions are clearly set out, and all members must comply with them. Communication, so always being open to communicating with the RICS promptly. If you're ever sort of called to provide CPD or any information, you must always try and act on that as promptly as possible. So ethical behaviour, I think, goes back to acting with integrity, acting with honesty. Competence, so always providing the best level of service that you can do, making sure that you're acting in accordance with best practice guidance out there. Service, so always trying to provide the best advice possible to your clients and providing a really high level of service. CPD requirements, so all RICS members must undertake a set amount of CPD per year, and demonstrate a good commitment to lifelong learning. Solvency, so always making sure that you're financially responsible and remaining solvent and not going into debt or letting your accounts go overdrawn. Information to the RICS, so always cooperating with any RICS communications and giving them information when requested. And cooperation, so always cooperating with the RICS as far as possible. If there's any sort of information that they need, making sure that that's sent as quickly as possible. As a follow-on question, you may also get the query, what are the RICS rules of conduct for firms? So again, these are 15-fold. So again, I really think it's worth just spending that 15 minutes to half an hour going through these in quite a lot of detail. I won't go through each of these now just for time purposes, but I think some of the key ones are complaints handling procedure. You've got to have a complaints handling procedure that's in line with the RICS processes. Again, handling clients' money, there are a very prescriptive set of criteria that firms must abide by in order to be compliant with the RICS guidelines. Professional indemnity insurance, being responsible in the way that you advertise your business and displaying the RICS logo sensitively and in accordance with the RICS guidelines. Again, solvency, always making sure that accounts don't go overdrawn and acting in a responsible way in regards to your finances. Arrangements of cover for any incapacity or death of a sole practitioner, so you've always got to have those arrangements in place if you are a sole professional, that in the event that you were unable to perform your professional duties, that there would be a contingency measure in place for somebody to ensure that business is continued. So question 11, what sorts of information do registered firms have to send to the RICS annually? So these are some of the things that you have to send through as a RICS registered firm. So an annual return. You also must advise the RICS of the types of business that you're undertaking and your staffing levels, the nature of the clients that you're dealing with. You must advise them of any training provisions that are in place, any complaints handling procedures, details and records, your professional indemnity insurance details, and also whether the firm holds any client money. So question 12, again going back to the RICS rules of conduct for firms. So one of these sets out that all our RICS firms must have a complaints handling procedure in place. So a question that you may get on follow-on to this is what processes should that complaints handling procedure include? So to answer this, you could say that the RICS provides a model form that all members have access to and can base their complaints handling procedure around to make sure that they're compliant. It must include a redress mechanism. Details should be issued to the client with the terms of business. It must be clear, quick, transparent, impartial and free of charge. Names and contact details of the nominated investigating person must be stated. The complaint must be investigated within 28 days. All companies, their progress and outcomes must be recorded. All complaints rather. You must note the need to advise PI insurers of any complaint. It must have at least 2 stages as a minimum. The first stage is that there should be consideration by a senior member of the firm or a designated complaints handler. And the second stage of the process should be that if it's not resolved, it's referred to a independent third party with the authority to award redress. So question 13, so assuming you were successful in getting chartered, how would you deal with a situation such as a friend asked you to provide them with QS or surveying advice? So some of the considerations that I would recommend giving to this kind of question would be that you could not offer advice on your own without the professional indemnity insurance in place. If you did have your own professional indemnity insurance, you should ensure that the information given was subject to the thorough check-in process given to all your clients, regardless of who it is. You must inform them that they can contact you during work hours to discuss the T's and C's of appointment. If you are not comfortable acting for them, advise them to use the RICS Find a Surveyor scheme. You must always be sure to adhere to the rules of conduct also. So a very basic level 1 question, but again, certainly something that you will definitely need to know about for your RICS final assessment. So what is professional indemnity? What does PII stand for? So this obviously stands for professional indemnity insurance. What is the purpose of professional indemnity insurance? Maybe a follow-on question to this. So this is in place to provide financial cover in the event of a client suffering a financial loss as a result of your breach of professional duty. So if you were to undertake your services and there was some element of professional incompetence there, or neglect or error or an omission, your professional indemnity insurance would step in and cover you for any financial losses. So what benefits does this provide for the professional and for professional firms? So the benefits of this are that the professional is protected from financial losses. And it also allows the firm to facilitate a potential claim from a client that is not met from their own assets and resources. So it allows continuity of business. So in regards to professional indemnity insurance, you may get another follow-on question. So this is quite a complex area now, and again, I definitely recommend dedicating quite a bit of time to this, just to go through and make sure that you're fully aware of the RICS requirements around professional indemnity insurance. So on what basis should the professional indemnity insurance be underwritten? So this should be on a claims made basis. You then may get another follow-on question asking you what a claims made basis actually means. So this is where the insurance policy that is in place at the time of the breach is discovered. That is a policy that comes into effect and allows any financial losses to be contributed to. So it's always the insurance policy that's in place at the time that will cover you for any potential financial losses. It's also not the insurance policy in place where the breach is made, so you can always add further detail to that. So question 20, again still on insurance here. So you may get a question asking about a famous piece of case law in the industry, which is the Merritt versus Babb case. So to answer this question, you could refer to this being a court case in 2001. Where Babb had done a valuation as an employee of a company for a house purchased by Merritt. That valuation was later found to be negligent. At the time that was discovered, the original company that Babb had worked for no longer existed. The court ruled that Merritt could pursue the individual, so they could pursue Babb for the final financial losses, and this was a really big shock in the industry. You may then get a follow-on question to this asking what the significance is of the Merritt versus Babb case. So the real significance of this is that if a professional employee was vulnerable to claims brought directly against them for advice given, you're acting as a employee, you yourself can be vulnerable to claims brought against your own firm if they cease to exist. It really highlights the importance of having run-off cover in place. So professional individuals and firms must always ensure that run-off cover is in place after they leave the firm, if they retire, or if that firm ceases trading. And individuals should ensure that their ex-company keeps up the cover on their behalf. So again, still focusing on insurance here. So how long should run-off cover be in place for? So just to highlight a bit more around run-off cover, so this is insurance that you need to make sure that you have in place. So if a firm ceases trading, this will continue to cover that firm and its employees for a set number of time. So as a follow-on question to this, how long should run-off cover be in place? Well, this really depends on the type of contracts that the professional has been involved with. It's usually for 6 years if a contract is executed underhand, although it can be up to 12 years if a contract is executed as a deed. So question 23 then, so what are the requirements regarding professional indemnity insurance for the RICS? So as we've already alluded to, this must be made on a each and every claims made basis. The RICS guidance does give a minimum policy wording that firms and members must adhere to. It sets out the minimum levels of indemnity required. It also sets out the maximum levels of uninsured excesses. It advises that run-off cover must be in place for a minimum of 6 years, and should also include cover for past and present employees, directors and partners. So again, still sticking with insurance. I hope this is not getting too boring for everybody now, but as I say, it is a real complex area and something that you need to know in relatively a lot of detail. So what are the minimum levels of indemnity, and how do you determine the level of PI cover? So this depends on the firm's turnover. If turnover is £100,000 or less, then the minimum level of indemnity is £250,000. If turnover is between 100 and 200,000, the level of indemnity increases to a minimum of 500,000. If turnover is above 200,000, then the minimum level of indemnity is 1 million. Then another follow-on question, so what are the maximum levels of uninsured excess? So to answer this, you can say that this depends on the level of indemnity. So up to 500,000 is greater than 2.5% of the uninsured sum, or £10,000. Over 500,000 is 2.5% of the insured sum. So question 26. So what measures should be taken to try and avoid professional indemnity insurance claims? So some of the steps that firms can take to avoid claims is to keep a full and detailed record of any meetings and conversations, to always record the recommendations and advice given, using proper letters of engagement, scope of services and terms of engagement, not advising on any specialisms outside your field of experience, using the RICS guidelines, and avoiding poor management and excessive workloads. So question 27, again, is really going back to the RICS ethics and professional standards. So this is just, again, testing your knowledge around the RICS ethics. So question 27 is, if you put together a fee proposal, but a couple of months into the job you realise that you have under-forecasted your resources, would you go back to the client and ask for more money? So these are really the grounds that you could base your potential question on. So if the project requirements, services or scope have increased, then potentially there is an argument there to go back and ask your client for more fees. But if the overall scope of services and requirements has remained the same, then unfortunately this is your own mistake or your firm's mistake, and you'd have to try and deal with it and resource the job adequately, but obviously try and look to get that right next time around. You should also be sure not to reduce the levels of service or the levels of resource that you'd offered that client originally. So again, that goes back to the always providing a high standard of service to your clients. So question 28, so as we've already alluded to, so all the RICS members must commit to lifelong learning and development, and must always undertake a set amount of CPD requirements annually. So the assessors could potentially test your knowledge around this, and they may ask, what are the CPD requirements for RICS members? To address this, you could first of all refer to the requirements being introduced in January 2013. All members must undertake and record appropriate lifelong learning, and on request provide evidence that they have done so to maintain and improve the levels of professional competence. All members must undertake a minimum of 20 hours CPD each calendar year. Of the 20 hours, at least 10 hours of that must be formal. So to be formal CPD, it has to have a set learning objectives and criteria and recorded set outcomes. So that could be something like a professional test or a professional course that you've been on with set learning objectives. Members must maintain a relevant and current understanding of the RICS professional and ethical standards during a rolling 3-year period. So question 29, again, another very common question that I've heard a lot of my colleagues get over the last few years is, how is the RICS structured? So this is just a organogram from the RICS website. So just to touch on each of these areas, so the Privy Council is the external body that grants the RICS with its Royal Charter, and they effectively set out the bylaws by which the RICS is regulated. The Privy Council cannot intervene with any RICS affairs. They have merely set the bylaws by which the RICS are governed, and that allows them to be a self-regulated body. The Governing Council is the main governing body and sets the overall strategy for the RICS. This is made up of elected members from around the world. The Management Board is to inform and oversee RICS affairs, and they report directly to the Governing Council and execute the strategy that's been set by the Governing Council. The Standards and Regulations Board is responsible for overseeing and setting of standards and upholding them within the RICS. The Audit Committee monitors the integrity and effectiveness of the financial reporting, internal control and risk management systems. So question 30 is, what are the RICS bylaws? So there are 10 bylaws in total. Again, I won't go through each of these individually just for time purposes, but there is a download copy of this available on the RICS website that I really think it's worth printing that off and just getting to grips with that and spending some time revising the bylaws and what their meanings are. So just to touch on a few of these very briefly. So number 1, so applications and definitions. So this has the definitions set out in the bylaws. So for example, it defines the Royal Charter, the designation after members' names and the entrance fees. Memberships and registration, so this refers to professional members, fellows, non-professional and honorary members. Number 4, so contribution of funds are the fees payable by different types of members and firms. Conduct, so this is always ensuring that members report in a prompt manner. If there's ever sort of a criminal offence that's been committed, you must always inform the RICS very promptly. Members may have to answer to a disciplinary panel if there's any failure to adhere to the bylaws, and all members must always be sure to conduct themselves in a manner that's befitting of the RICS and not bring the RICS into disrepute. So another very common question then is, who is the president of the RICS? So the answer to this currently, at the time of recording this video, is Timothy Neal. Obviously, depending on the time of your sitting of the APC, always be sure to check that this information that you give is current, so always be aware of who the president is of the RICS. A follow-on question that you may get to this is, what are they up to currently? So in this case, having done some very quick research around Timothy Neal and the RICS, so they're currently focusing on the RICS's COVID-19 response and outlining the RICS's overall approach, including what they are doing to maintain global operations and service delivery to uphold standards in the built environment in the face of the global pandemic. They're also providing guidance for professionals, so supporting professionals to continue to deliver to the public advantage by addressing key concerns and risks. So key topics currently include how valuations, client visits and inspections are undertaken in the face of the global pandemic. They're also providing best practice advice to small and medium enterprises, including practices on working remotely, advising on remaining solvent, and also carrying out audits, again, all in the face of COVID-19. So this is a very hot topic at the moment that you can really talk in some depth about. So question 34 is probably an uncommon question. I haven't ever heard of a colleague being asked this before, but I think it's just essential that you are aware of the date the RICS was established. So this was established on the 26th of August 1881. Another question, which again I think is more of an uncommon question, but I have heard of a couple of people being asked this. So what is the motto of the RICS? So this is Es modus on rebus, the Latin phrase which translates into there is measure in all things. So question 34 again goes back to your understanding of the RICS ethics and rules of conduct. So if you were bidding for a piece of work and a client approached you and said that you can have the job but you need to beat the current best price of a competitor of £12,000, how would you respond to this kind of offer? So you have to tread very, very carefully in this instance, because what's just offered does effectively form a bribe. So these are just some of the key points that I'd really recommend talking about in order to try and address this kind of question. So the offer to try and gain an advantage over your competitor with inside information is effectively a unfair competition. You could then say that that's not acting with integrity or with honesty. It's also not treating the other surveying firm with much respect there as well. So you're really hitting on three of the big global professional and ethical standards there. You could potentially argue that you could offer a reduced level of service for the reduced fee, although I'd tread very carefully there around doing that. You must always make sure that a fair and open competition has been undertaken and be very transparent with that offer. You could say that there's potentially an argument there for devaluing the profession and devaluing surveying services. So if you're being asked to undercut a competitor, if you continue to conduct business in this manner long term, all that's going to happen is that surveyors are going to really compete against each other and lower our services and our value long term. So it's really not good business practice for the profession. It's not a sustainable way to operate. As I say, in adjusting your behaviour in order to gain an advantage, that is a form of a bribe. So it's essentially illegal in accordance with the Bribery Act 2010. And I'd just always say in your response to that it's no real way to conduct business in this manner, and just be very, very cautious and say that you would essentially respectfully decline that offer from the client. So question 35 is what is a consent order, or which are now called regulatory compliance orders. So a regulatory compliance order is an agreement between the RICS and a regulated member that they are liable for disciplinary action. So this is a admission of where the standards expected by the said member have fallen short of what is expected. There is a agreement to a appropriate sanction, In some cases, there will be steps taken to meet the standard expected and to prevent the compliance order from happening again. Question 36 is, what is a fixed penalty? So a fixed penalty is a administrative fine or caution issued by the RICS when a regulated member fails to provide us with information that we have requested. Any fixed penalty issued and not rescinded will remain on a member's record for a defined period. So question 37, so again this is a very hot topic. So we've obviously already talked about the Bribery Act. You may get a specific question on what the principles are of the Bribery Act. So bribery is defined as the offering, receiving, giving or soliciting of something of value for the purpose of influencing the actions of a official in the discharge of his or her legal duties. The Act only applies to the bribery of local officials. So UK companies and foreign companies operating in the UK have the duty of having corporate measures in place to prevent bribery and have in place control measures. Companies are liable to pay fines if they don't have these. Individuals can receive a combination of a fine and a prison sentence of up to 10 years, so a very, very serious subject here. Again, another very hot topic at the moment is, what are the principles of GDPR? So this is essentially assuring that you act in a lawful manner with fairness and transparency. There is data minimization, accuracy, storage limitation, integrity and confidentiality. There must also be accountability that's demonstrated by firms in order to protect client and business data. Again, another very hot topic here. So what are the principles of money laundering regulations 2017? So I think with all of these subjects, so definitely with the Bribery Act, with money laundering regulations and GDPR, I'd just really spend some time revising the key principles of these pieces of legislation. Now focusing on the money laundering regulations. So these set out the additional obligations of private sector firms working in areas of higher money laundering risk. So in particular with solicitors firms, certainly with estate agencies and surveying firms where you're dealing with quite large sums of money at times. Those kind of firms must demonstrate that they aim to stop criminals by using professional services to launder money, and that requires ourselves as professionals to take a risk-based approach. So question 41, again, really going back to the 5 global professional and ethical standards. So you find out that your brother is working outside of the confines of the RICS. He's a chartered surveyor. What would you do in this instance? So first of all, to answer this question, you could say that you would verify the facts with your brother and confront him, reminding him of his duties as a member of the RICS. You could also say that you would inform the RICS, specifying your relationship to that person in question and any corrective action which you believe that person is committed to put in place. Question 42 is a very common question that I hear a lot of candidates being asked. So can you tell me about a piece of CPD that you've undertaken recently? So in your response to this, obviously this is going to be very specific to yourself, but always include in your response whether it was formal or informal, what were the learning objectives, and what was the outcome. You could potentially then get a follow-on question asking you what the difference is between formal and informal learning. So formal is classed as web-based training with structured assessment, formal seminars, providing training to others where research and preparation is required. Informal CPD is classed as private reading internal CPD within a firm, and shadowing and mentoring a trainee. So question 44 is, how will you record your CPD and return this to the RICS? So in your answer to this, you can say that there is a portal on the RICS website where CPD can be recorded. This must record the type, date, subject area, the number of hours, the learning outcome, and the learning objectives. Potential question again that I've heard one or two colleagues get over the last few years is, what is currently on the latest copy of Modus? So these kind of questions are really just making sure that you are somebody who keeps up to date with current affairs in relation to the industry. So just always have an appreciation of this and some of the topics that are currently in the press. I think you'd be quite unlucky to get this sort of question, but I think essentially the assessors may check that you are up to date with current affairs in relation to the industry. So I'd always recommend just trying to have an appreciation of what's on the cover of Building Magazine, things like Modus, and just having an appreciation of the topics that are covered recently. You may get a question on how you keep up to date with current affairs and topical issues within the industry. To address this, you could say that you are on the mailing list for several CPD providers. You could say that your employer sends out a monthly digest of relevant press articles that's of interest. You could exchange information with colleagues, obviously refer to the RICS website and journals. We've also mentioned things like Building Magazine, Modus Magazine, Estates Gazette that you could refer to. You may get a question on what is your CPD strategy. To answer this, you could say that you meet with your line manager, set regular intervals throughout the year to define your career development plan and objectives. You could say that you build your CPD strategy around those objectives based on current topics and personal interests. You could then refer to what your current objectives are for that particular year. A very common question that I hear a lot of candidates get asked is, why do you want to become a chartered member of the RICS? To answer this, you can say that you see the RICS and RICS membership as being the gold standard of your profession. The level of guidance, notes and support that the RICS offer their members will allow you to provide a better level of service to your clients. You could say that you know the RICS designation, so the letters behind your name, is highly valued by clients and will further your career development and opportunities. Finally, you could also say that you are committed to lifelong learning, professional and personal improvement, and believe that the RICS will support you in achieving those objectives. And just finally, you may get a question asked on what the purpose is of the RICS. Again, to address this, you can say that the RICS promotes and enforces the highest standards, professional qualifications in the development of and management of land, real estate, construction and infrastructure. The work of the RICS professionals is hugely varied and includes providing best practice guidance to industry professionals and governments, influencing best practice in industry working policies, protecting consumers and businesses, and developing assets in the built environment so they are fit for future generations. That brings us towards the end of this Q&A video. I really hope you found that useful. Please, as I say, if you do need the PDF copy of these notes to support your revision, please be sure to check the link in the description below, like and subscribe to this channel. Thank you.